All right, the next case is 24-1772, Comelco, Inc. versus FCCI Insurance Company. Counsel for appellant, please introduce yourself and let me know how much time you'd like for rebuttal.
Good morning, Your Honor. Tim Taylor on behalf of Appellant Comelco Incorporated. I'd like 5 minutes for rebuttal.
Thank you, Mr. Taylor.
May it please the court? Good morning. Once again, my name is Tim Taylor. I represent the Appellant Comelco Incorporated. This is an appeal that arises from an underlying lawsuit filed by Orange County against my client Comelco for construction deficiencies on an exterior lighting project at the Orange County Convention Center. The facts of that underlying case are somewhat controlling to this appeal, so briefly I need to get into those facts. As alleged, Orange County was the owner of the project who hired my client Comelco as a licensed electrical contractor.
Mr. Taylor, I think we're pretty familiar with the facts of the case. I'd like to jump right to your work exclusion if we could.
Sure.
You rely on Posi Window. I know you argued Posi Window in your briefing for the property damage side of things. But again, I want to focus on your work exclusion. You also rely on Posi Window for that. But first of all, isn't Posi Window a coverage case? I mean, they didn't take your work exclusion head on in that case, did they?
Well, Your Honor, I believe they did, and here's why. Because under the insurance policy, it's an insuring agreement to cover property damage. Okay, so property damage is defined in the insurance policy as damage to tangible property. Obviously, then there are exclusions. Well, first off, if you have property damage, they have to pay. So if you have,
there's an exclusion.
sure, and if we go to Posi Windows, Your Honor, and it's at 1248, and here's why I say they did address it. Because when they were discussing the CGL policies in Posi as well as JSUB, they write, the CGL policies define, quote, property damage as, quote, physical injury to tangible property, including all resulting loss of use. In JSUB, we explained that the other courts have also, quote, recognized that there is a difference between a claim for the cost of repairing or removing defective work. That's your work exclusion, which is not a claim for property damage. So that's where we're getting it. If you can't have property damage and your work exclusion, because property damage cannot be part of your work. So in this case, when you have, if something is defined as property damage under the insurance policy, it can't necessarily also be part of your work exclusion.
So why have the exclusion?
Well,
If coverage is the end-all be-all of it, then why have the exclusion? And on top of that, why have the separate E&O coverage portion of the policy? If that's the end-all be-all of it, then there's no need for the exclusion because it's effectively swallowed by the coverage.
well, the exclusion of your work is the insured contract for work. It's that scope of work. Property damage is outside of that. So therefore, if property damage isn't part of the insured scope of work, it can't be part of your work exclusion. And that's why the Florida Supreme Court makes that distinction in Posi and says, look, if you're giving owner-supplied materials that are not part of the insured construction contract, they are considered property damage and not part of the work being performed by the insured contractor. And therefore, that's why when they discuss this, they say recognizing there's a difference between a claim for the cost of repairing or removing defective work, which is not a claim for property damage, and a claim for the cost of repairing damage caused by the defective work, which is a claim for property damage. So they're discussing the interplay between the your work exclusion and what is considered property damage. And that's why when we get into the Posi and they talk about if a claim is for the repair or replacement of, you all know, it was windows that were not initially defective but were damaged by the defective installation, then there's physical injury to tangible property, which is what we have in this case. We have lighting fixtures that the county bought from a company called Traxon for hundreds of thousands of dollars and contracted with my client, Camelco.
So I have questions for your colleague about the trial court's decision on coverage, because it doesn't make any sense to me based on the Posi Windows case. However, if we look at the plain text of the your work exclusion, just answer me two straightforward questions. Are the lighting fixtures materials? And two, who furnished them?
Good questions. One, they're not materials under the your work exclusion because they weren't furnished as part of the insured contract. The contract is insured.
How do you get to that under the plain? If I were to ask a fifth grader, I'm giving you this box that has this light fixture in it, and I want you to open the box and screw in that light bulb over there. Would you say that this light bulb is a part? I mean, doesn't the fifth grader say, of course it's a part?
I'm not necessarily understanding that distinction, but I want to go to what you talked about, your work, and you said materials. Under your work, it's
sure. Materials, parts, or equipment furnished in connection with such work.
Key. The key word is furnished in connection with such work or operations. The work or operations has to be the insurance. And so in this case, the lighting fixtures were not furnished in connection with our work or operations. We didn't furnish them. They were the owner's separate material and tangible property that they hired us to install. And that we can look at the
owner furnished the light fixtures to Camelco to be installed and connected and to make them work, right?
That's right.
So they were furnished by someone in connection with Camelco's work.
Exactly. It's the same situation as Posi, where the owner furnished the windows.
So why does it matter according to the policy language who furnished them? They were furnished.
Well, it's furnished in connection with such work or operations. The such work or operations is of the insured under the policy.
Yeah, but we've established that Camelco installed the lighting fixtures.
Right, but they didn't furnish them.
And I think we're in agreement about that. Why does that matter? Because does the policy language require the materials to be furnished by the insured, or does it only require that they be furnished in connection with the insured's work?
They have to be furnished by the insured because the insured is getting paid for them. See, when they fall under the contract of the contractor supplying the materials, that is part of the contractor's work. Because the contractor's furnishing those materials, it's part of his contract sum that he's getting paid for by the owner. It's part of the umbrella of scope of work in his contract.
I'm sorry, if we look at just the plain language, as my colleagues are pointing out, so the paragraph 22, the definition of your work, materials, parts, or equipment furnished. If I just take a plain language read of this contractual language, there's no distinction in who's doing the furnishing. Shouldn't the policy have specified, and aren't you asking this court then to add a requirement in that the materials, parts, or equipment only be furnished by the insured, when the language of the policy doesn't say that? Aren't you asking this court to make that additional requirement?
Well, I have two responses to that. One is, as you've noted, it doesn't say who furnished it. Okay, so all ambiguities in the insurance policy are always by law in the state of Florida ruled in favor of coverage for the insured. Therefore, since, as you said, it doesn't say who, just based upon that argument, there would be afforded coverage. But secondly, this is the same exclusion post 1986 CGL policy that the Florida Supreme Court was analyzing at JSUB, was analyzing in Posi. This definition hasn't changed. And if you start putting tangible property that is not part of the insured's contract as exclusions, it's almost impossible to underwrite that policy. It's easy to underwrite the policy when you know what the contractor's scope of work is, what he's furnishing, what he's doing. But if there's going to be arguments later about adding, well, owner furnished these, these materials, or another third party furnished other materials, isn't that now excluded? Well, no, it's not part of the contracted for scope of work. It's not part of the work of the insured. And this was a labor-only contract for Camelco. It was a licensed electrician installing the owner's products that that they purchased from an international lighting company called Traxon. So if we look at Octor, which is what the trial court relied on, that was presented by FCCI in this case. Even the Octor court noted, it's a federal case. I don't believe it has any precedential value. It's sort of odd that you've got a split decision with a concurring Dubitante opinion that says, this needs to be certified to the Florida Supreme Court, but I'll concur Dubitante. But if you look at what Octor says, they make the distinction. Look, they're saying there would have been covered for these owner-supplied materials, but for, in Octor, these were raw materials, in this case, building tiles, roofing tiles, part of the roofing system that was assembled on site to create a completed system. They called it raw materials. Okay? Raw materials assembled on site, some of which were provided by the owner. And in Octor, the damages was the replacement of the entire roofing system. So it's raw materials in a system, some material supplied by the owner, but the owner wants a whole new roof because it was impossible to replace just some of the tiles. Therefore, it was a system, and the system is part of your work. Here, we have specific specialized lighting enhancements that are made overseas by an international lighting company that are shipped to the project, paid for by the owner, and the owner hires an electrical contractor to just install them.
Who
and then the
furnished
owner
these lights to your client?
What's that?
Who furnished these lights to your client?
The owner furnished these.
I mean, how isn't that the end of the inquiry as it relates to your work exception? They were furnished to your client.
Because owner furnished materials are considered property damage and not considered part of the work.
Right. And you're relying on Posi Windows for that, which is a coverage case.
That's right.
Which doesn't deal with exclusions.
Well, respectfully, I believe.
And Octor doesn't deal with exclusions either, right? It's a coverage case.
Once again, they both go to whether it's property damage. If it's property damage, and as Posi said, look, we're looking at property damage versus what amounts to your work exclusion or damages caused by your work. And because, as in Posi, as it noted, owner-supplied materials are considered tangible property. I mean, that is the law of this state. And the reason why it's such a policy issue here, in public construction contracting, there is such a large amount of owner-supplied materials for the tax breaks that the owners get. So there's going to be, on every job, 10 to 20%. In this case, it was 100% of the materials, but materials furnished by public owners, so they don't have to pay, they get the tax break exemption, it lowers costs, and they're making sure, obviously the contractor has GL insurance because they want to make sure everything is insured, including their products. If we go beyond that, and all of a sudden we go outside of Posi and we start saying owner furnished materials are not covered property, is not tangible property. One, I believe we'd have to have an opinion and take that up to the Florida Supremes to resolve that issue. But two, it creates an insurance coverage nightmare on these construction projects because
So I think we perhaps just might be talking past each other. Every time you say coverage, we agree with you.
Can't we find that there is coverage due to property damage, but also find that your work exclusion applies?
No, I don't. I don't believe so, because if owner-supplied materials are considered tangible property under Posi, tangible property is not part of the your work exclusion. Property damage has a definition, and property damage means physical injury to tangible property, including all resulting loss of use of that property. If you have tangible property, which Posi Windows has defined as property damage to owner-supplied materials, it cannot be part of the your work exclusion because your work exclusion doesn't include tangible property. It includes only your work under your contract. So that's why I don't believe. I think we're having a fundamental disagreement about whether you can have a decision identifying owner-supplied materials as tangible property and then say, but nevertheless, it's excluded under your work exclusion because the two can't coexist under the insurance policy. You either have tangible property or you can have a lot of things, but your work would include work that is not considered tangible property.
Then shouldn't your work exclusion have said in terms of the furnishing that the materials, parts, or equipment can only be furnished by the insured? Shouldn't it have made that distinction in your work definition?
Well, respectfully, I think when you talk to The section's called your work. So when we're looking at, quote, your work, it means being a possessive pronoun, means it's your materials, parts, or equipment furnished in connection with such work or operations.
That you do, except that it does recognize or could be on your behalf. I'm looking at the definition paragraph.
Oh,
22 of your work.
Yeah, you're right. And what that means, that's subsection 1, which is work or operations performed by you or on your behalf means subcontractors. Okay? And then subsection 2 talks about the materials, which is what we're here under. And materials, parts, or equipment furnished in connection of such work or operations is under the, quote, your work. That applies to what the insured is furnishing. And that's a very logical interpretation that follows Posey Windows. If there's another interpretation, once again, the ambiguity would have to go in favor of coverage.
Counsel, you're into your rebuttal time.
I appreciate the heads up, Your Honor. I will save the remainder of my time for rebuttal. Thank you.
Good morning, Your Honors. May it please the Court, Alana Ullman on behalf of the FLE FCCI Insurance Company. Thank you for your time this morning. I'll dive right into the issues and the inquiries posed by this Court. It seems that the focal point is the application of the your work exclusion. I have many fundamental disagreements with counsel's statements about the law and application of your work in conjunction with the existence of property damage. I believe the case law supports and the plain reading of the policy supports the conclusion that the two very much can and must coexist. You don't get to the your work exclusion unless there is property damage. And I think the case law makes that clear. In the Octor decision from the 11th Circuit, which does rely on Florida Supreme Court precedent, the court notes that, I'm sorry, in JSUB, actually, actually in JSUB, the court said that the subcontractor's exception to the general exclusion for contractors' defective work becomes important only if there is coverage under the initial insuring agreement. So the court acknowledged in JSUB that we don't even get to discussing your work unless there's coverage under the initial insuring agreement. So we're past the point if your honors are inclined to find that there was property damage because, to counsel's point, the lighting fixtures themselves were the property purchase owned by the county. Then the next inquiry is there an exclusion that applies? And the your work exclusion falls squarely within this. The terms are broad. The definition, the exclusion provides that property damage, so we have to assume that there's property damage already, property damage to your work arising out of it or in any part of it included in the product's completed operations hazard. And then the definition, I don't necessarily agree that 22A2 is the only term that's relevant here. I think equally 22A1 applies because the property damage is to or arising out of the general work and operations of Comelco here.
Well, it'd have to be both, right? Because there's an and.
Yes, but I think both apply just as importantly here in this context.
But in order for the exclusion to apply, both would have to apply.
No, yes.
Well, it's not an or.
Well, no, because it's the your work is a definition.
Yeah.
Yes, I agree. And I also want to add that the court correctly acknowledged that the JSUB and the Posey Window cases do not involve the your work exclusion. The courts maybe tangentially address the your work exclusion, but they were not relevant there because the insured in that case was general contractor that outsourced the work to subcontractors.
I mean, neither is Octor, which is how the Octor is a coverage case. I mean, it more specifically says we don't have to reach the your work exception. So it's interesting to me because the only, and I expected your colleague to mention it at some point, but the only authority that's offered as it relates to the applicability of the your work exception is this Pinkerton case, which is a Northern District of Georgia case from 2002. And that has a pretty interesting way of defining furnished. And it talks about furnished in the context of furnished meaning materials, parts, and equipment that are furnished by the contractor in connection of doing the work. So in this case, screwdrivers, hammers, ladders, stuff like that. Could you please address Pinkerton? I understand
Yes.
that you disagree with it.
Yes.
But there's no textual analysis of Pinkerton in the answer brief, nor was there any textual analysis made below of Furnished or Pinkerton in front of the trial court.
Sure.
So it seems to me that if your colleague has a hat to hang, it's going to be on that definition of Furnished and Pinkerton.
Yes, absolutely, Your Honor. Well, first and foremost, as you noted, Pinkerton was a U.S. District Court case from Georgia. I understand it construed
But
Florida
I mean,
law.
you won the case on a split panel from the 11th Circuit. So.
Yeah, no, I acknowledge that. That court addressed the impaired property exclusion, not your work. And I think that's relevant here.
It did. It talked about your work specifically under L.
It looked to the definition of your work, but it did not involve the question of application of the exclusion your work. It involved impaired property, which references your work, and reference to the definition was required. I don't think that it involved the question of the specific exclusion involved here, damage to your work, which is property damage to your work arising out of it or in any part of it, and included in the product's completed operations hazard. I think that it's much broader than an impaired property exclusion, M. Here, I think broadly the court can reach the conclusion that if we assume there's property damage, that the property damage was to the insured's work, which is defined as work or operation performed by you and materials, parts, equipment furnished in connection. Again, to your point raised earlier to my colleague, that there's no modifier that distinguishes who furnished the work. I think the plain reading is that your work embraces and encompasses materials, parts, or equipment that are furnished in connection with your work. And readily, often we see in the industry that the supplies are brought in by other contractors or owners and from other sources. And these exclusions are intended to be business risk exclusions to preclude there being coverage for any time there's just faulty workmanship to the work itself. If there was work, for example, if the lighting fixtures fell off and hit the ground and hit somebody or broke something, that's not necessarily damage because of your work.
What of his argument that furnished is an ambiguous term, that work can mean that it would be equally likely that it could be lighting fixtures furnished by the owner versus hammers, ladders, or screwdrivers furnished by themselves?
I don't think it's an ambiguous term. I think there's a plain reading. I think the discussion in terms of ownership of property in this context, at least under Florida precedent, is limited to the question of, is there property damage? And I think we've overcome that based on the questions of this court, that this court's inclined to find that there is, at least at a minimum, property damage. But I think looking past that, I don't believe that there's ambiguity in the term furnished. I think it's a plain reading that equipment is provided.
Just
doesn't
on
modify
that
by
point,
whom.
though, quickly, counsel, as it relates to coverage, like how are we not bound by posi windows? I mean, regardless of what the policy says.
On the property damage front?
Yeah. How is there not coverage in this case?
We're looking past the exclusion, just in terms
Well,
of
you're not even
property
to the
damage front.
exclusion yet if there's no coverage, which is what the trial court decided.
Yes. So I think posi window can be distinguished in a couple of manners. I mean, I'm not negating the conclusion to posi window, and I don't think Ofter is necessarily contrary to posi. I think its conclusions were reached based on posi. But that case had some factual distinguishers in it. There was substantial damage to the windows themselves in that case. That was the focal point of that case. The entire framing of the windows, everything was wrong with the windows themselves. And the court said that they focus on, the ownership issue to say that, well, that could be other tangible property, and therefore there could be property damage. But it was because the focus was on damages, that the claimant in that case was alleging damages because of the issues with the windows. And in this case, the issue is not damage to the lighting fixtures. That's a misnomer. The focus is on the issue.
You mean, do they work?
But they're non-functional. Them being non-functional is not the same as property damage. So if I have a perfectly good television set and I install it, but I plug it in wrong and I mess up the wires, I didn't install it correctly. Did I do a faulty installation of the TV? Maybe, but is there damage resulting from it? That's not the issue in this case. I mean, I think this is important. Just I had this thought of driving here was would the claim would the county still have their claim and the same quantum of damages they could seek against Comelco here for the improper wiring and non-functioning of the lights, even if there was not a single allegation or issue in terms of damage to the lights, no water infiltration, no issue? Could they still make their claim? Would they have still the same quantum of damages because they're just inoperable, not that they're damaged? I think they would. I think the issue is that they didn't adhere to, or allegedly didn't adhere to the terms of the contract, the bid agreement, that required wiring to be done in a certain way, use certain types of equipment or whatever it may be, and they didn't, and it's not operable. Not that there's necessarily damage. And what's being sought here in the way of damages in the underlying case is to remedy the defects of the installation, the faulty installation here. And that's exactly, I think, Your Honors noted that there is E&O coverage under this policy, and that was properly paid here by the carrier. And the insured paid premium for E&O coverage with the understanding that the policy has exclusions for liability arising out of their work and their faulty work when the damage is to that work. The purpose of a CGL policy is not intended to provide coverage for those types of losses. And that's why, there's bill of risk purchase here, there's a surety involved in the underlying case, and those are there for a reason.
Counsel, if we disagree with the trial court on coverage, but we agreed with the trial court on the your work exclusion, we would have to affirm. But I want to step away from that one for a moment and talk about the contractual liability exclusion.
Yes.
I don't find much in the case law that's really persuasive from a textual standpoint of explaining what does assumption of liability under a contract mean. Because when I look at the word assumption, when I look at the Black's Law Dictionary, for example, it's pointing to taking on a liability that wasn't otherwise yours to take by contract. It doesn't seem to me to communicate simply, well, it's work you're doing pursuant to a contract, therefore the contractual liability exclusion applies. Can you help me textually get to why that exclusion applies in this case where the contract required them to install the light fixtures?
Yes. No, I don't disagree. There's not a lot of legal authority that addresses this head on. We did cite to the Key Custom case. I believe it's might be a federal court decision from the Middle District of Florida. But that case addresses, and acknowledges that you can have breach of contract claims that are covered under CGL and those that are not. There are some that arise out of tort and some that arise out of contract. And I think you really need to look into what the damages are being alleged here. And in the Key Custom case, I think it was a faulty construction that resulted in a house fire case. But the court said that although the property damage was tangential to the claim, the only relief being sought was for a breach of the contract due to not adhering to a certain substantial completion or repair protocol, something along those lines. And I think that's akin to the situation we have here, because essentially what I understand Orange County is alleging.
For a second, just so I make sure I understand that factual pattern. So you had a fire that arose as a result of a contractor's defective remediation work?
Not necessarily as a result of, but it was a consequence of the construction. There was a fire, and there was the house burned down. But the relief being sought in that case was under a theory of breach of contract due to failure to adhere to certain terms. I believe it was a substantial completion issue related to that, or timeliness issue that was negated by the fire.
Remediation would make sense because that contractor would be taking on the risk of a previous contract to complete it. Where I struggle with the trial court's decision on this particular exclusion is that in the normal course of talking to each other in the business community, when I enter into a contract with you as a plumber to fix the pipes, you're not assuming my liability for the pipes, which strikes me as the way that the trial court looked at that particular exclusion. In other words, the idea is, the owner and Comelco had this contract that had these specifications, and the argument is that they failed to meet those specifications. That doesn't strike me how I understand assumption of liability. It's just a contract.
Yeah.
Now, if they were fixing somebody else's mistake under a contract, maybe you could get me there, but it's hard for me under the pattern.
I understand. And that wasn't the focal point of our arguments in the trial level. So I understand why the decision really doesn't flesh that out. But I believe the case law would support the conclusion that the damages being sought here by Orange County against Comelco are economic in nature, based on the contract and a liability assumed to perform in consistent with the specifications. And the allegation is that they didn't use this right device or this right equipment or whatever it may be. And not that that resulted in damages, but that the property is not operable. The lighting fixtures are not operable because of that. And so for that reason, we preserved and argued that the contractual liability exclusion would be a third tier basis to preclude coverage here. But the crux of our position is that the year work exclusion applies. And that's why FCCI issued its E&O coverage that does not impose a duty to defend, but it does have a minimum limit, I believe, of a $10,000 limit, which was promptly issued several years ago. And I don't know if it's worth the argument on the whether or not there's property damage at all. It seems that the court hasn't been decided on that. Our position is just that we believe that the Octor case does shed light on the property damage inquiry that's most akin to our situation, because although there was not a subcontractor, there's a subcontractor situation in that case and not in ours. In Octor, there was owner-supplied equipment or owner-supplied materials for the roof, and the court was able to reach the conclusion that because the issue was really with the installation and the roof as a whole, not just the individual roof tiles that were supplied, that was not property damage. And we believe that this is a similar type of situation where the focal point, the issue here is not the lighting fixtures themselves. It's the lighting system, which was the entirety of the scope of Comelco's contract. And we believe that's the reason, and that supports the trial court's decision to find there was no property damage in the first instance. And, I'll just end with, we did raise an argument in the underlying court and in our briefs just to preserve the issue on building code violations not constituting an occurrence. And I don't know if that merits much time. Candidly, I don't believe that that's a very strong argument here. But I do would kindly ask that the court uphold the trial court's decision finding that there is no duty to defend or indemnify in this case.
Thank you, counsel.
Thank you.
Thank you, Your Honors. Just briefly, I'd like to just remind this court that Chandler versus Geico Indemnity Agreement, Florida Supreme Court case has held that ambiguous language is construed against a drafter.
Yeah. You talked about that. Let's talk about that, because I think that if we get into Pinkerton, we're talking about furnished. So let me ask it to you this way. Let's say you're a contractor, and we're talking about your tools. And if you pick up your hammer, would you say I furnished myself this hammer, or it's my hammer? Because if that's an ambiguous term, and Pinkerton is either right in how it defines it, or it's ambiguous, then I think you're right. I think you win under that particular circumstance. I will tell you personally that I'm struggling with the idea that a contractor can furnish itself with its own equipment. Typically, when we talk about somebody furnishing somebody to something to somebody, I'm giving it to you.
And let me answer that in the context of how Florida has defined the lien law and furnishing, because furnishing is a big thing on liens and also bond claims. So when a contractor furnishes labor, materials, services, or equipment, he can furnish all four: labor to do the work, materials, rebar, concrete, whatever. Equipment, he brings his heavy equipment in, generators, whatnot. He uses that equipment to improve the real property and it takes away, but he's furnished it. You have lien rights for the time that equipment is on the project, helping you to construct the project. And that's where you get to the furnishing. You can furnish your own equipment. It doesn't necessarily, equipment doesn't normally stay in the project. You're just using it to build. So, but you've got to furnish it yourself for you to have those rights. Okay. And I think when we get into Pinkerton, that's what they also said. It's what is the contractor furnishing? The court in Pinkerton is following Florida lien law. When they're talking about furnishing under the insurance contract, it's the same thing. They don't consider, the contractor doesn't furnish to a project materials given to him by the owner. The owner's furnishing those materials to the project. The contractor's installing those with his labor. He's furnishing his labor, but he's not furnishing those materials. And that's why when I started with the applicability of the law and the ambiguity always going in favor of the insured, and especially in that case, you see exclusions are even a higher, more strict standard than just the regular interpretation of coverage. Looking at Pinkerton, they're following Florida law and they're following Florida lien law, but they're not necessarily saying, because that's how lien law.
Out of curiosity, in your research, did you find a Northern District of Georgia case from 5 years after Pinkerton called Johnson Landscapes that disagreed with Pinkerton? Or I'm sorry, that didn't mention Pinkerton, but also addressed furnished?
Johnson, I'm not familiar with that case.
It's okay. I didn't find it either. Somebody on this panel did.
Oh.
So, okay. I just wanted to ask.
But Johnson, I'd like to look that up. What was it? Johnson Landscapes?
Johnson Landscapes, yeah. And basically, for what it's worth, they disregarded Pinkerton's analysis on what furnished meant, basically saying it doesn't make any sense that you would furnish something to yourself.
And was that case interpreting Florida law?
It was not interpreting Florida law, but it was interpreting the same provision in the CGL policy.
Sure, because you can go to Chapter 713, which is the lien law statute, and it'll just define what furnishing is. And so you could look at
How does the lien law's definition, and it's an interesting point that you raise, it's the first I've heard of it. How does the lien law's definition of what furnished meant give us any technical guidance as to what furnished means in the context of a CGL policy?
Because it shows who's furnishing. You know, you have to actually be the party furnishing or those on your behalf if you're a general contractor furnishing. Therefore, as a general contractor can lien, he can lien for all of the work that is substituted as well, and everybody down the line who have purchased the materials that are incorporated for the project. The general contractor cannot lien for owner-supplied materials because he's not furnished them either through himself or his subcontractors. So when you lien a property, it's got to be for labor, materials, or equipment that you have the lienor has furnished for the improvement. And obviously that, implies and expressly states that the lienor's got to be responsible for those materials, labor, and services. So in that regard, I think it's instructive on when you get to your work, it's your work. It's what you're furnishing, what the lien law allows you to lien for. It's just another how the Florida legislature has determined who furnishes. So I see that I'm out of time, Your Honor. Respectfully, we would request that you reverse the trial court's summary judgment against my client, declaring that there is no duty to defend, and find that there is a duty to defend, and consequently vacate the ruling approving or the summary judgment for the appellate FCCI. Thank you.
Thank you.